So in this video, I'm going to show you why a listing agent in California breaches their fiduciary duty to the seller every time they allow the seller to offer buyer agent compensation in California, unless they're an attorney. So first of all, let's go over what a fiduciary duty is of the seller's agent. This is from the California Code, and it's also in the disclosures that we, as I'm a real estate attorney and a broker, that we give to our clients. A seller's agent under a listing agreement with the seller acts as the agent for the seller only. A seller's agent or subagent of that agent has the following affirmative obligations: a fiduciary duty of utmost care, integrity, honesty, and loyalty in dealing with the seller. Now, here's the issue. The listing agent goes to the seller and says, I can help you sell your home. Now, they know ahead of time, 85, 90% of the time, if not more, a third party will be representing a buyer. They'll draft up a contract and they will ask that seller to pay buyer's agent commissions. Now, buyer's agents have learned to ask for the maximum amount in the area on the vast majority of the situations. They see the training on the internet, and in my experience, that's what I've seen too. I'm a broker and an attorney. And so now we're looking at 2.5 or 3% of the cost of the home being requested for buyer agent commissions. Now, this is high because normally a buyer wouldn't agree to pay 2.5 or 3% out of their pocket. They'd actually say $30,000 on $1 million home. I'd rather use that as a down payment. So normally, if a buyer agent and a buyer were left to their own negotiations, they might offer $2,000 or $3,000, maybe $5,000, occasionally $10,000, incredibly rarely $25,000, $30,000. But because they have this form, because they have to ask the buyer to write the amount they're going to pay in writing on the California Association of Realtor form before they even show the property. That is not the law in California. The amount does not have to be determined until as soon as practicable, but no later than when they're drafting and executing a contract. So this early timing, where buyers are weakest, is when they're told, don't worry, we're asking for 2.5 or 3%, but we'll get the seller to pay for it. Every listing agent should know that that's what's happening. Now, the form comes over. So here's the BRBC. This is the agreement they'll sign, and they'll write in this agreement that the buyer will pay 2.5 or 3%. Now, on the purchase contract, there's this form G3, and it comes over and it says seller's payment to buyer's broker, and they'll ask for the 3%. So that's going to be in the vast majority. You're selling your house. This is likely to happen in at least one of your offers. Someone's going to be asking for buyer agent compensation. Now, that's normal, right? And in the past, an attorney referring their client to a listing agent wouldn't worry about it. A listing agent can handle this. Well, a listing agent could handle it because in the past, before the class action suits, it was the listing agent's money. They'd ask for a 6% listing and offer 3.5% on the MLS. That's no longer the case. And as we showed earlier, even in the California Association of Realtors' own forms, it says that the listing agent no longer has any forms related to buyer agent compensation. The listing agent has no clauses to counter. The listing agent has no language. They're not given any authority to represent them in this matter with respect to buyer agent compensation. They can't call the buyer up on the phone or the buyer's agent, discuss buyer agent compensation. It's a third-party contract, and they're not attorneys. I have no idea how this is happening, but about 200,000 times in California this year, a seller will be allowed to pay buyer agent compensation. This is just rough stats from the AI, and there'd be no attorney on the team. I don't know how it happens. Additionally, every time a seller agrees to pay buyer agent compensation, they're now on the hook for the risk that the DOJ talked about of steering, of compromising the fiduciary duty of buyer's agents, which is almost guaranteed. Those things are almost guaranteed to be part of this transaction. If a percentage was paid, and even on the DRE website, it said somewhere, the buyers can walk if the seller doesn't agree to pay buyer agent compensation. Like, that's the whole point. That, if you, even though you have a contract in your hand, you're going to pay that buyer agent because they might walk if you don't agree to pay it. That's steering. You're saying, I will pay you to stay here because otherwise you'll steer your client away from my house. It's built into this process. So only an attorney can mitigate against it, because this could be significant. This would be easy. This is easy. I'm not going to go suing agents. I'm an attorney and a broker. I've worked for, I've helped them train real estate agents. I haven't worked. They asked me to train real estate agents on how to negotiate buyer agent compensation, on how to negotiate short sales. I like the car lawyers, but these forms, there needs to be a disclosure that says a listing agent cannot negotiate buyer agent compensation. They can't respond to it. They can't advise on the risks. They can't, like, if I'm a seller and I love my offer and I have a lot of assets and I'm moving to a different state, I might not need to do much in terms of risk mitigation. But if this is the only money I have and I need to buy another house and I'm going to be house poor in the new house, I can't afford to be sued later. I can't afford a class action suit seeing that I didn't, that I offered percentage-based compensation and could have compromised the buyer, the fiduciary duty of the buyer's agents. I mean, it's just nuts. Like, there's mitigation measures. And a listing agent's not trained to do that at all. They're not licensed. They have no idea, actually, most of them, what they're doing. They haven't read the cases. They don't understand the class action suits. They don't understand what the DOJ said. They don't understand what the DOJ said in the No Select case, in which No Select said, and I'm sure the buyer will be happy to know that their buyer agent's not incentivized to have them pay more, and what that means, and how that's a slam dunk problem if you see a percentage-based compensation. That's just so out of their realm, but it's real. So they can't respond. They don't have language to do this. Like, we'll talk about this in one of the next videos. In the Sipper case, when they were defining what practicing law without a license, it's responding to a counterform and writing in terms like these, choosing whether to bifurcate the process into two separate negotiations, one for the home, one for realtor compensation. That would be the preferred way to do it, because it would put pressure on the buyer and the buyer's agent to get the deal done now closer to the seller's terms, because the agent knows the longer this goes on and the less buyer pays, the more likely they're going to counter and reduce the buyer's agent commissions so the seller can have a stronger net. So, I mean, that's one thing listing agent can never do. I don't even know how the buyer could respond unless you actually, and this is what I would advise, you create the forms for this transaction to go well. And in those forms, based on the seller's risk, you also mitigate things. Listing agents can't do any of that. And yet, they're 200,000 times approximately, they're going to let their sellers do that this year on every sale without an attorney. And they have the utmost duty of care, just even if they didn't know all these legal things I'm talking about. How do they look a seller in the eye without any forms, without any language, without any risk mitigation, and say, I can help you sell your home without an attorney? I mean, that's implicit. How can they do that without an attorney? How can they look someone in the eye and say, I'm here to sell your home? And I'm going to tell you what most of them do is they just let that term stay. Oh, well, you don't want to counter that because the buyer will walk. So 2.5%, 3%, a material aspect of your client's equity, gone. Just gone. When they already have an offer in hand. That, like, if it done well, they might not have to pay 2.5% or 3%. They might have to pay $5,000. If they have multiple offers, it could be $2,000. It could be $0. I saw that happen in my negotiations when we had 9 offers. So, but a listing agent can't do any of that properly. They can't get on the phone and talk about it. So how can they look a seller in the eye and say, I can sell your home for you? And 2.5% or 3%, probably more than the difference between what the contract will be and the price of the home. In my experience, homes sell for with 1 or 2% of the list price very, very frequently. All the data I see, my experience, in the good days, we go 1% or 2% frequently, almost every time, above ask. This is 2 or 3%. This attaches massive risk. This isn't being leveraged. If listing agents could leverage buyer agent compensation than would in the past, the seller could sell their homes for a lot more money. None of that's being explained to sellers. There is just no way that this isn't a material breach, a material clause in the contract that they can't respond to. This is a fiduciary breach at its core. California Association of Realtors has to create disclosures in which the listing agents say, you need to speak with an attorney before you sign this agreement. I mean, I don't mind if they don't. The point is, I'm going to suggest that how you could work with a broker attorney like myself to straighten this out. But I'm just, I'm not saying it's the end of the world. I'm saying that every home sale in California, if a buyer agent wants to get paid, there's going to have to be a partnership between an attorney who knows what they're doing and a realtor who knows what they're doing. And that's why I've started listingattorney.com. Thank you. Oh, by the way, but the point is, I have a lot more to explain. What the risks are, what the risk of steering is, what the risk of compromising the fiduciary duty of the buyer's agent is, what the risk of price fixing is in this process and keeping prices high, and then how to mitigate those risks. Those that will be in this series. And in the end, I'll also explain to the attorneys that want to get paid, especially on their files from their own clients, a process they can use. Because on the HUD, they're probably worth $10,000 worth of attorney time, maybe more. But on the HUD, asking for more than 2 is going to be a problem. I will suggest a method that attorneys can use working with listing agents that would be RESPA compliant. It would be the bar. It'd be okay with the bar. Like the bar doesn't want you getting kickbacks. RESPA doesn't want you getting kickbacks. They're illegal, actually. And you're supposed to be doing the work. Well, I'll show you high value work that you will do on every file. In fact, if you did all the work, you'd be worth more than half. But I'll show you the high value work that would easily comply with the amount of money you want to make on these files, because it's very high value. And that's part of the series. It's all free at listingattorney.com. My name is John McConnin. Thank you.